Welcome back to online classes. Dear students, I'm James here. Today I'm going to discuss with the Indian Penal Code under section 375 of IPC subclass G. Okay, this 7th class, gang rape. So what are the main ingredients of this case? Here, to bring the offence of rape within the purview of section 376 subclass 2 subclass G of IPC, read with the explanation 1 of the IPC, and it is necessary for the prosecution to prove: number 1, that more than one person had acted in concert with common intention to rape the victim. Number 2, the more than one accused had acted in concert in commission of crime of rape with a pre-arranged plan, prior meeting of mind, and with element of participation in action. The common intention would be action in concert in pre-arranged plan or plan formed suddenly at the time of commission of offence, which is reflected by the element of participation in action or by the proof of the fact of inaction where the action would be necessary. The prosecution would be required to prove pre-meeting of minds of the accused persons prior to commission of offence of rape by substantial evidence or by circumstantial evidence. And also the third point of this section, that in the furtherance of such common intention, one or more persons of the group actually committed offence of rape on victim or victims. The prosecution is not required to prove actual commission of rape by each and every accused forming group. In order to establish an offence under section 376 subclass 2 of subclass G of IPC, read with explanation 1 that 2, the provisions must adduce evidence to indicate that more than one accused had acted in concert and in such an event. If rape had been committed by even one, all the accused will be guilty irrespective of fact that she had been raped by one or more of them, and it is not necessary for the prosecution to adduce evidence of completed act of rape by each one of the accused. In other words, this provision embodies a principle of joint liability, and the essence of that liability is the existence of common intention. That common intention presupposes prior concert, which may be determined from the conduct of offenders revealed during the course of action, and it could arise and be formed suddenly. But there must be meeting of minds. It is not enough to have the same intention independently of each of the offenders. In such cases, there must be criminal sharing, marking out of certain measures of jointness in commission of offence on proof of common intention of the groups of person, which would be of more than one, to commit the offence of rape. Actual act of rape by even one individual forming group would fasten the guilt on other members of the group, although he or they have not raped on the victims or victims. Okay, victim or victims. In appeal, it was contended that there are no injuries on the prosecutrix of infer rape. There is no merit in this contention in view of fact that prosecutrix was a married woman and was overpowered by several men before she was raped. She was obviously not in position to resist and fight several harm who had threatened her with death in case of cried out. There is, however, ample of evidence of rape in view of the forensic report regarding the clothes of prosecutrix and those of the appellant. The report clearly discloses the presence of semen spots and human sperm on the clothes of accused, including the apparent on the prosecutrix. Conviction also is upheld. Okay students, I think this is enough for this class. That means section 376 subclass 2 of subclass G of Indian Penal Code. And another point of view, woman accused of gang rape. A bare reading of section 375 of IPC makes the position clear that rape can be committed only by a man. The section itself provides as to when a man can be said to have committed rape. Section 376 subclass 2 makes certain categories of serious cases of rape as enumerated therein attract more severe punishment. One of them relates to gang rape. The language of subsection 2 of subsection G provides that whoever commits gang rape shall be punished, and etc. also. This explanation only clarifies that when a woman is raped by one or more in a group of persons acting in furtherance of their common intention, each such person shall be deemed to have committed gang rape, with the subsection subclass 2 that cannot make a woman guilty of committing rape. This is conceptually inconceivable. The explanation only indicates that when one or more persons act in furtherance of their common intention to rape a woman. Here, each person of the group shall be deemed to have committed gang rape. By operation of deeming provision, a person who has not actually committed rape is deemed to have committed rape even if only one of the group in furtherance of the common intention has committed rape. Here, common intention is dealt within the section of 34 of Indian Penal Code and provides that when a criminal act is done by several persons in furtherance of the common intention of all, each of such person is liable for that act in the same manner as if it was done by him alone. Here, common intention denotes action in concert and necessarily postulates a pre-arranged plan. A prior meeting of minds and an element of participation in action. The acts may be different and vary in character, but must be actuated by the same common intention, which is different from same intention or similar intention, the sine qua non, that is legal maxim for bringing in application of section 34 of IPC, that the act must done in furtherance of common intention to do a criminal act. Here, the expression in furtherance of their common intention as appearing in explanation to section 376 subclass 2 relates to intention to commit rape. A woman cannot be said to have an intention to commit rape. Okay students, we'll discuss another section next class. Okay, thank you all. Bye, see you.